The Napoleonic Code. Europe's most celebrated legal achievement, standardized written contracts for land, debt, and marriage in 1804. Filipino barangays were already operating all four of those contract categories in writing, with witnesses and enforcement mechanisms centuries before that. The source for this claim is not a Filipino scholar making a national pride argument. It's a Spanish colonial friar who documented the entire system in 1589 while his own government was actively dismantling it. That gap between when the Philippines had it and when Europe caught up is a minimum of 239 years. Depending on how early you date the documented use of these contracts, some records point back toward 900 CE. The gap could be closer to 900 years. Hold that number for a moment, because we'll come back to it. First, let's be honest about why 1804 matters. The Napoleonic Code is genuinely one of the most important legal documents in Western history, and it deserves that reputation. Before it existed, European contract law was not a system. It was a mess. A patchwork of leftover Roman statutes, Catholic canon law, feudal customs that varied from one county to the next, and regional ordinances that sometimes directly contradicted each other. A debt contract that was valid in one French province could be meaningless 30 miles away. Land inheritance worked differently depending on whether you were dealing with church land, noble land, or common land. Marriage property rights were essentially whatever the local law decided they were. England didn't produce anything resembling a standardized contract framework until the mid to late 1800s. That's not an insult to England, it's just the timeline. What the Napoleonic Code did in 1804 was take all of that fragmented chaos and compress it into one coherent written civil system. Property, debt, marriage, unified, written down, applicable across an entire nation. Historians are right to call it a milestone. It earned that label. So when we say Filipino barangays were doing something comparable centuries earlier, we're not comparing them to the chaotic pre-Napoleonic patchwork. We're comparing them to the finished product, the gold standard. And the comparison holds. Here's where the debt contracts come in, and they are worth your full attention. Juan de Plasencia was a Spanish Franciscan friar. In 1589, the colonial government commissioned him to document the legal customs of the Tagalog people. Not to celebrate them, not to preserve them, to understand them well enough to replace them with Spanish law. The document he produced is called Customs of the Tagalogs, and it currently sits in the Philippine National Archives. Modern legal historians cross-reference it constantly. What Plasencia described in that document, regarding debt alone, is more structurally nuanced than what most European peasants were working with at the same time. Filipino debt contracts were written agreements, not handshake deals. Written in Baybayin script, on bamboo or leaves or animal skin. They named witnesses, they specified terms, and the terms themselves had internal layers that would look familiar to any modern contract lawyer. There were graduated interest tiers, different rates depending on the type of debt and the relationship between the parties. There were collateral clauses, specific property designated as security against default. And there were debt bondage conversion clauses, a formal mechanism by which unpaid debt could convert into a defined period of labor obligation with its own terms and limits. At the same time in Europe, a peasant who borrowed grain from a lord had essentially no written protection. The lord's word was the contract. The lord's mood was the enforcement mechanism. In a Filipino barangay, the written document existed. The witnesses existed. And the authority to enforce it existed in the form of the Datu, the community leader who served as contract witness, dispute arbiter, and enforcement officer simultaneously. This was not one man's unchecked power. The Datu's authority was contingent on community legitimacy. A Datu who enforced contracts unfairly could lose standing. There was accountability built into the structure. Now here's the question Plasencia's debt contracts raise. If that single category was this sophisticated, what did the other three look like? Land transfer contracts came with boundary markers, inheritance rules, and sale conditions. All written. Not just a verbal agreement that a piece of land passed from one family to another, a document, with terms, specifying what the boundaries were, what happened to the land when the owner died, and under what conditions it could be sold. Marriage covenants addressed something that European legal systems mostly refused to touch for centuries, the property rights of both parties before and after dissolution. A Filipino marriage contract in the pre-colonial period included what each person brought into the marriage, how those assets would be treated during the marriage, and, crucially, what happened to property if the marriage ended. most European women had no legal claim to marital property until the late 1800s. In England, the Married Women's Property Act wasn't passed until 1882. In a pre-colonial Filipino barangay, the dissolution terms were written into the marriage covenant before the marriage began. Both parties had documented rights. The fourth contract category is the one that shifts the scale from civil to political, war alliance contracts. Written mutual defense agreements between barangay leaders. Formal, documented, witnessed. You could call them primitive treaties, and you wouldn't be wrong. Except primitive is doing a lot of dishonest work in that sentence when the document contains specific mutual obligations, defined trigger conditions, and the signatures of community leaders. Taken individually, each of these categories is impressive. Taken together, they map exactly onto the four pillars of any functioning civil society: commerce, property, family, and security. This is not a collection of random local customs. It is a complete legal architecture, which makes the next fact the most important one in this entire story. Plasencia didn't write his 1589 document to save any of this. The Spanish colonial government didn't commission it out of curiosity or respect. They needed a detailed map of the Filipino legal system because you cannot efficiently replace something you don't understand. The document is not a preservation effort. It is a demolition blueprint. Every debt contract Plasencia described in detail corresponded to a community that was about to lose the written protections that contract represented. Every land transfer rule he documented was a rule that Spanish colonial law would soon void by requiring all land titles to be re-registered under Spanish format. Any prior documentation, any baybayin written deed, became legally worthless overnight. The friars who created the most detailed record of pre-colonial Filipino contract law were the same people systematically destroying it. Their administrative thoroughness. The colonial bureaucrats need to understand what he was replacing. Accidentally produced the primary archaeological evidence that the system was real, functional, and sophisticated. What was intended as a tool of erasure became, centuries later, the proof that something worth erasing had existed. The mechanism of that erasure is worth understanding clearly, because this is where the pre-literate narrative gets manufactured. Baybayin literacy was in active use across multiple island groups before Spanish arrival in 1565. Spanish friars noted, in their own records, that literacy rates in the Visayas and Tagalog regions surpassed what they observed in contemporaneous Spain. That's not a Filipino source making an optimistic claim. That's the colonizers writing home about what they found. Within 2 generations, Latin alphabet instruction replaced Baybayin in colonial schools. The script didn't fade out because it was obsolete. It was deliberately replaced as part of administrative control. And the materials that Baybayin documents were written on, bamboo, leaves, animal skin, degraded over time. Stone archives and vellum are European advantages. They are material advantages. They are not civilizational ones. The absence of surviving original Baybayin legal documents is not evidence that the documents never existed. It is evidence that perishable media degrades and that colonial policy discouraged preservation. The narrative of Filipino pre-literacy is an artifact of colonial archival decisions, not historical fact. There is another document worth naming here. The Lorca account of 1582, written 7 years before Plasencia, describes Datu contract enforcement practices in enough specific detail that modern legal historians can cross-reference it against Plasencia's document and reconstruct the system's architecture from 2 independent colonial sources. 2 colonizers, writing separately, describing the same functional legal infrastructure. That's not legend, that's corroboration. The University of the Philippines College of Law has formally integrated pre-colonial legal history into its curriculum as documented indigenous jurisprudence. Not folklore, not cultural heritage in the soft sense. Jurisprudence, the study of legal systems. The Institutional Legal Academy of the Philippines treats this as recoverable legal history because the source documents support that treatment. And the system didn't only survive in academic papers. Contemporary indigenous communities in Mindanao continue to practice customary law contract forms that carry direct structural continuity to the pre-colonial categories: customary land agreements, formal community dispute processes, written and witnessed debt arrangements within community frameworks. These practices are now legally recognized under the Indigenous Peoples' Rights Act of 1997, a Philippine law that formally acknowledges the legal validity of indigenous customary law within the national legal framework. The pre-colonial contract system did not die in 1565 when the Spanish arrived. It was suppressed. It went underground in communities that colonial administration didn't fully reach. And in 1997, the Philippine state formally acknowledged that it had never stopped existing. Which brings us back to 1804. Europe celebrated the Napoleonic Code as the birth of modern contract law. Historians across the Western tradition point to it as the moment when written, standardized, enforceable civil agreements became the legal default. It was genuinely a milestone. Filipino barangays had a four-category written contract system: land, debt, marriage, and war alliance, with named witnesses, enforcement authority, and accountability structures built in. The debt contracts had graduated interest tiers and collateral clauses. The marriage contracts had dissolution terms and property rights for both parties, protections that European women wouldn't see for another 3 centuries after Plasencia wrote them down. The war alliance contracts were functioning written treaties between leaders of sovereign communities. All of this was operating centuries before 1804. Some of it was operating before 900 CE. The story wasn't lost to history. It was filed. Filed in the colonial government's own administrative records by a friar who was trying to build a replacement system and needed to know what he was replacing. It sat in archives. Legal historians found it, cross-referenced it, confirmed it, taught it. Your ancestors didn't wait for Europe to invent the idea of legal rights. They wrote them down first. One question worth leaving open. The Indigenous Peoples' Rights Act of 1997 legally recognizes the continuity of this system today, which means it has formal standing in Philippine law right now. What other pre-colonial civic systems? Trade networks, governance structures, environmental management agreements are buried in similar colonial administrative records, waiting for the same kind of reconstruction? The Plasencia document was found because someone looked. The question is, how many more demolition blueprints are sitting in archives that haven't been read as the accidental preservation records they actually are? Of the 4 contract categories, land, debt, marriage, and war alliance, which one do you think was most ahead of its time? Leave it in the comments. There's no wrong answer, but the marriage covenant tends to surprise people most when they see what European women were living with at the same point in history. The debt contracts surprised the legal historians. That's usually where academics pause longest when they read Plasencia. Not because debt is dramatic, but because the structural complexity is hard to dismiss. Graduated interest tiers mean the rate you paid depended on your relationship to the lender, the size of the obligation, and the collateral you put forward. That is not a simple system. That is a layered system with internal logic designed to handle edge cases. It had conversion clauses, points at which an unpaid debt could convert into a labor obligation, with defined terms for how long and under what conditions. The lender couldn't just decide. The terms were written. The witnesses saw them. The Datu knew them. Compare that to what a peasant farmer in France owed a local lord in the same period. That agreement existed in the lord's memory and the lord's mood. There was no written tier. There was no conversion clause. There was power and proximity, and that was the contract. The material difference matters too, and it gets used against the Philippine record in ways that deserve a direct answer. European legal documents survived because they were written on vellum, treated animal skin, and stored in stone buildings. Philippine contracts were written on bamboo, leaves, and animal skin that was not treated for long-term preservation. They degraded. This gets read as absence of evidence. It is not. A house that burned down was still a house. The floor plan exists in the insurance record. Plasencia's document is the floor plan. The Lorca account from 1582 is another floor plan. The Spanish colonial administration, in its bureaucratic efficiency, created multiple redundant floor plans for the legal system it was burning down. Cross-reference those documents and the architecture of the system becomes clear enough that the University of the Philippines College of Law put it in the curriculum. Not as folklore, not as cultural heritage in the soft sense, as documented indigenous jurisprudence, as law. That distinction matters. Folklore is a story a community tells about itself. Jurisprudence is a functional legal architecture with identifiable rules, enforcement mechanisms, and documented outcomes. The pre-colonial Philippine contract system meets the second definition. It has been categorized as such by legal scholars working from primary sources, not from national pride. The Datu role is where the system gets most underestimated by outside observers. Because Datu gets translated as chief and chief gets read as tribal, and tribal gets read as informal. None of those translations are accurate for what Plasencia describes. The Datu functioned as witness, arbiter, and enforcement officer within one community role. Their authority to enforce contracts was not inherited absolutely. It was contingent on community legitimacy. A Datu who enforced contracts unjustly lost standing. That accountability loop is not primitive. Many European magistrate systems in the same period had less formal accountability than that. When Spanish colonial law came in, one of its first administrative moves was to dismantle Datu judicial authority and replace it with Spanish alcalde courts. That was not incidental. That was targeted. You don't replace a function that doesn't exist. The replacement proves the original was there and was working. Every land title had to be re-registered under Spanish format, voiding all prior documentation. Within 2 generations, Baybayin literacy had been replaced by Latin alphabet instruction. The perishable originals were gone. And the absence of originals started being cited as proof that there had been nothing to preserve. That is the mechanism. It is not complicated. It is colonial archival policy operating exactly as designed, and then the design getting misread as natural history. The narrative of Filipino pre-literacy is not a historical finding. It is an artifact of what got saved and what got let degrade. Stone archives versus bamboo. Latin instruction versus Baybayin. That is a material and administrative gap, not a civilizational one. The Spanish friars who documented the system noted. In their own records, that literacy rates in the Visayas and Tagalog regions were higher than what they observed in contemporaneous Spain. That is not a Filipino historian's claim. That is the colonizers' own field notes. The same documents that record the suppression of Baybayin also record the literacy rates of the communities whose writing system was being suppressed. Read together, those records describe a society that was more literate than the one replacing it, operating a more nuanced contract system than the one replacing it, and governed by a more accountable local authority structure than the one replacing it. That reading is now in a law school curriculum. It took a while to get there, but it is there. The living continuity is real too. Indigenous communities in Mindanao practice customary law contract forms today that carry direct structural continuity with the pre-colonial categories. The Indigenous Peoples' Rights Act of 1997 gave those forms legal recognition under Philippine national law. The system was suppressed. It was not killed. Parts of it kept functioning in communities where colonial administrative reach was incomplete, and those parts are now formally acknowledged as law. That means the 4-category contract system has an unbroken line, documented in 1589, reconstructed by legal historians, taught in law schools, and formally recognized by a 1997 national statute. That is not a historical artifact. That is a living legal tradition that survived colonial replacement and came back into formal standing. Your ancestors wrote down legal protections for their land, their debts, their marriages, and their alliances centuries before the system credited with inventing that idea was born. The Napoleonic Code is genuinely important. It unified a fragmented European legal landscape and spread a coherent civil law framework across the continent and beyond. That is real. And it happened in 1804. The barangay debt contract with graduated interest tiers and collateral clauses was already there. The marriage covenant with dissolution terms and property rights for both parties was already there. The war alliance written between sovereign community leaders was already there. Plasencia read them. Plasencia described them. Plasencia's government used those descriptions to build a replacement. The Demolition Blueprint is in the archive. It was always in the archive. It just took someone reading it as evidence of what existed rather than instructions for what to erase.